Okay, we'll get started. Good afternoon, everyone. I'm Shadi Nasseri, a doctoral candidate here at Osgood. My distinct pleasure to welcome you to today's.
And is that your whose phone is last?
Oh, it's me.
I think that's the last.
Sorry, my. So today's discussion is about defending the absolute nature of freedom of thought. Please note this event is being recorded. And once again, thank you all for joining us for what promises to be a very rigorous and timely scholarly exchange. I am especially honored to welcome our distinguished guest, Professor Christoph Bublitz, all the way from Germany. He joins us in conversation with our very own Professor Hingama Saberi, and in a moment, our Associate Dean of Research, Professor Francois Tengwe-Renaud, will formally introduce Professor Bublitz and situate his work for us. However, before we proceed, I'd like to begin with a land acknowledgement. York University recognizes that many Indigenous nations have long-standing relationships with the territories upon which York University campuses are located. Relationships that long predate the establishment of the university itself. York University acknowledges its presence on the traditional territory of many Indigenous nations. The area known as Toronto has been caretaken by the Anishinaabe Nation, the Haudenosaunee Confederacy, and the Huron-Wendat. It is now home to many First Nations, Inuit, and Métis communities. We acknowledge the current treaty holders, the Mississaugas of the Credit First Nation. This territory is subject to the Dish with One Spoon Wampum Belt Covenant, an agreement to peaceably share and steward the lands and waters of the Great Lakes region. We offer this acknowledgement in recognition of the enduring responsibilities that accompany our presence on this land. Without further ado, it is my pleasure to invite Professor Francois Tengwe-Renaud to formally introduce our distinguished guest. Please join me in welcoming him.
Good afternoon, everyone. On behalf of Osgood Hall Law School, it's my pleasure this afternoon to be introducing Professor Christoph Bublitz. Professor Bublitz is a legal scholar at the University of Hamburg. His work or research interests are really focused on criminal law and human rights law, as well as legal theory. And on point for today, the intersections between law, philosophy, and cognitive science. So, Professor Bublitz is very active in these fields as a scholar. His name is not new to us. Just as a little snapshot of things he does, he's currently the primary investigator of two international and interdisciplinary research collaborations. So one concerns legal and ethical issues arising from the blending of artificial and organic intelligence through neurotechnologies, and the other concerns the return of psychedelics into medicine. He also convenes the Freedom of Thought Research Network. He is the co-editor of the book series at Palgrave on neuroscience law and human behavior, and his CV is just too long for me to continue to recount. So it's a real pleasure to have Professor Bublitz. This is a topic in which we're interested here at Osgood. What are you guys going to talk about today? This question of the absolute nature of freedom of thought, and how understanding the right in this way might have implications for how we protect individuals against non-consensual interference, the regulation of technology, and so forth. All the more important that one of my doctoral students, Amir Nahidi, is actually working directly on this topic. So I'm really happy that we're able to bring somebody like Professor Bublitz in-house to be able to be part of conversations that we're already having. So without further ado, Professor Bublitz, welcome to Osgood.
Yeah, so thank you for the kind introduction and the kind invitation, and especially thank you all for coming here in your lunch break, I would think. So I want to talk today about a very current issue that's being discussed not only in academia, but also in international institutions at the UN and in Europe at the Council of Europe, so important institutions in the human rights field. And it concerns the right to freedom of thought. And very basically, it's the question whether human rights law has the idea that certain parts of the human mind should be absolutely protected, meaning should be out of reach of governments and perhaps by extension also by private parties in a kind of like a principled way. That is the question, and that is the idea that's associated with the right to freedom of thought. And that is now, let's say, controversially discussed. And this has to do, of course, with emerging technologies, neurotechnologies, so technologies that actually can interfere and intervene into the mind and perhaps read out your thoughts. We'll be talking a little bit about this, but this is the background. This is why it has become such a hot topic. And now at the moment where these technologies emerge that may or may not interfere with freedom of thought, the debate about whether that right is an absolute right has emerged, and that's what I want to address today. So freedom of thought actually is a right. I know you have it in the Canadian Constitution, but as far as I know, even there, it's not really developed. Some Canadian scholars I spoke to call it a forgotten right in a sense. That's the same at the international level. So, but of course, I will not speak about the Canadian right, but the international right. And then perhaps we can later see how these relate to each other. But at the international level, freedom of thought really lives through a renaissance. It has seen a lot of attention. 10 years ago, nobody was speaking about this. Most people would not have known, is this really a distinct human right? We wouldn't even be sure. Nobody has been mentioning it. And now in recent times, it has seen a lot of attention. So let me see if I can change my slides. This would be great. What would I need to press? Oh, there we go. This one, okay. So, yeah, just to give you a little bit an overview. So, many international institutions now write reports about this. The Human Rights Council Advisory Committee has written on neurotech and human rights in 2024 and placed freedom of thought, gave it a very prominent place. Then we have the UNESCO recommendation on the ethics of neurotechnology. That's actually a soft law instrument that was adopted in last November, so pretty new. And surprisingly, among the states, everybody who was a member of UNESCO could become part of the negotiations. And Russia, China, and the US, they were all there, and they all agreed to this. I mean, it's only soft law, non-binding, but given the current political climate, that's perhaps at least something to remark. And even there, freedom of thought is one of the big principles. So freedom of thought is now a thing, a topic, but nobody really knows what it means. And this is what I want to talk to you a little bit. So I thought before we come to this absolute nature debate, I will give you a little bit of primer on the right to freedom of thought, telling you what you need to know, because many people may not be so familiar with it. So very briefly, an introduction. So freedom of thought first came in Article 18 of the Universal Declaration, 1948, and since then has been basically codified in all the international instruments, ICCPR, and so on. And it's traditionally, it is protected together with freedom of conscience and religion. So Article 18 is freedom of thought, conscience, and religion. Then in the American Convention, which many of you will be more familiar with than I, it has been a little bit reconfigured. Now I think there it is with freedom of expression. Freedom of conscience and freedom of religion are separate kind of rights. And the idea behind this seems to be that they wanted to make it clear that thought does not only refer to religion and conscience, which some people assumed and still do assume. So this is where we find it in international law. But of course, it's a large notion. It has a long history. It's a central term of the Enlightenment. So for Kant, to think for yourself. This was the central motto, and Voltaire used it. So it's a typical Enlightenment kind of concept. And in that context, it often has a rationalist kind of character. It means not just to think for oneself, whatever one wants to think. No, it means freedom of reason, to find out the truth, to advance science, to not follow the authorities, to make up your own mind, but not in an arbitrary way, in a way that's like trying to seek the truth, trying to find out how the world really is. So it's also often together with science, and obviously meant often against the church and religious authorities. And also, it's very often used synonymously with freedom of speech. In many writings, in Mill, for instance, he basically uses freedom of thought and freedom of speech synonymously. And that's, of course, fine. And I think in the US, in the culture wars, the people against cancel culture, they often appeal to freedom of thought. That's fine in a sense. From a historical approach, you can use it in this way. But this is not how it's used in the law. In the law, international human rights law, it's a little bit a technical term because we have a right to freedom of expression or freedom of speech, and we have other rights. So it basically there means it pertains to the internal side, so to the thinking as a psychological process, and that comes from a long tradition with freedom of religion and freedom of conscience, where it has been accepted for a longer time that there is something like the inner side, and it has this Latin term, forum internum, that is absolutely protected, and that basically arose from 30 years of wars in Europe. I don't want to get into this, but this is the idea. Freedom of thought pertains to the internal side, not to external manifestations. And that's what you see in Article 18 in the wording. It says about freedom of thought, conscience, and religion, and it doesn't have qualifications, and then it comes about external manifestation, worshipping, and so on. And then there's many limitation clauses. Okay, this is what you have to have in the background. So one may wonder, why do we have this right at all? So as I said, it is an innovation by the Universal Declaration. It was not a common thing before. As you are in Canada, you will probably ask, was it in the Humphrey draft? So the first draft of the Universal Declaration was written by John Humphreys, who was from McGill, and he made 50 articles and said, this should be the basis for the declaration, and it was not among them. So it was not a standard kind of thing that was known before. It basically was an innovation by two people. And the one guy is Charles Malik, who we see here. He was a representative of Lebanon, and he's a little bit a forgotten figure of the drafting. He was a philosophy professor in Beirut, and he studied at Harvard and also in Germany under Heidegger. But by chance, more or less, he became a diplomat, and he was a philosopher basically in the room. And he was, when they were sitting together in the commission, he was always saying things like, when we make this Bill of Rights, this list of rights, what should we include, what should we not include? And he was saying, well, it's very likely we will not forget the material needs, like food and shelter and those kind of things. But what we may oversee is that the human being is also an intellectual, thinking, spiritual being. So it has this anti-materialist kind of approach. And as a philosophy professor, of course, for him, educating the people and giving them freedom of thought by exposing them to philosophers in that sense was one of his big missions. And I will just give you one quote here from these debates. So he was also very concerned about the individual person being exposed to all those overwhelming pressures. This was the beginning, of course, of mass society and mass media and all these kind of things. And so he was saying something like, the modern state is becoming increasingly determinant of the very being of the person, and it does so by its laws, by psychological pressure, economic pressure, propaganda, social pressure. So the picture is always, there's the individual and it's exposed to all these stimuli and all these overwhelming influences. We have to do something against this. And what do we have to do against this? Well, we have to protect the inner freedom. And this is what freedom of thought then became, but it was never really spelled out much more clearly what this inner freedom is or what it comprises. It was understood, however, as a specification of human dignity. So this is always meant freedom of thought is an expression of human dignity. without really much more argument. But interestingly, when you look at freedom of conscience and religion and freedom of opinion in Article 19, it was thought that this is a sequence that goes from a hierarchy. So freedom of thought is the main right, because that's the thinking, the reasoning being, and freedom of religion and this internal side, freedom of conscience, the forum internal, these all derive from it. So this was the idea, and therefore they placed thought first in Article 18, and there were debates about this. And everybody agreed, in a sense, let's put thought first. And this was what I would say, this was a late triumph of the Enlightenment, because basically reason took over and came first and took the space that was originally given to the internal side of freedom of religion and freedom of conscience. Now, I said it's two people who were behind this right. One was Malik, the other was René Cassin from France. He later was awarded the Nobel Peace Prize for his work on the Declaration. So he's the not forgotten figure of the drafting. And why he was championing freedom of thought doesn't really become clear, but he's very strong in the French tradition. And so freedom of thought is a central idea of the French Enlightenment. That's probably what his reasoning was. And there's an interesting, I think, a little historical side note to this. We are in 1947 and 1948. That is where the question of Palestine, as it was said back then, was for the first time really becoming a problem. That was a time where the Nakba happened. And it's interesting that Malik, who was from Lebanon, he was a spokesperson for the Arab League, very outspoken against Israel. And Cassin, he was Jewish, and he lost many of his family in the Holocaust. So he was a Zionist. So they were really on the other side of the spectrum in this debate. But nevertheless, they were the ones who worked together on Article 18, and they really pushed this through. So in a sense, I think we can say that we have an interesting constructive collaboration here on the other side of the spectrum in Article 18. And I think that's something at least we should perhaps remark in these days. Okay, so much for the history. Now, since then, nothing has happened with this right. So there's really almost no case law at the international and national levels. I'm collecting these cases for 10 or 15 years now. If you have any, send it to me. I know there's a Canadian one on drugs, but which is a little bit off topic. So nothing has really happened. There is not much. There hasn't even, until today, there's not even a monograph by any legal academic on this, right? I'm writing one, but you're invited to write another one. So this is really underexplored in various regards. And the first thing that changed this was a report by the then Special Rapporteur, Freedom of Religion and Belief. And he wrote the first report at the UN level on this, right, in 2021. And since then, other institutions have followed him. Now, there's a little bit of a consensus what the scope comprises, many things, but two of them are that the right prohibits non-consensually altering someone's thoughts and non-consensually revealing unexpressed thoughts. Now, of course, immediately the question comes up, altering thoughts, don't we alter thoughts all the time? Yes, in a sense we do. So, and they already discussed this in the 40s. But at least severe influences on thought should be captured. And in the literature, we find examples of brainwashing, indoctrination, ideological reform camps. That was a thing in the 60s and 70s in some Asian countries. And also psychoactive drugs. If you give psychoactive drugs to people to affect how they think. So these are examples I would think most people agree on. And now comes neuroscience. So we must make a little bit of a jump now. So neuroscience, just very quickly, brain technologies, what do? They very basically, they have two modes of operation. So they can measure brain signals, for instance, with magnetic or electric signals, and then they can infer, sometimes they can infer something about the mental states of a person. It's a very complex thing. And it's not that we can already do this in on a wide scale, but this is basically the idea that some neurotechnologies allow to read the brain reading to infer mental states. And this includes, in certain situations, thought. And the other mode of operation is you can intervene into the brain, for instance, by giving a little bit electric stimulation to it, or now ultrasound is the new thing now. So you send signals or you send stimuli into the brain in order to have some effect, some changes, mental processes, and so forth. So now I'm saying this because these two, if we go back one slide, or I don't know, oh yeah, I can go back here. So these are the two things that fall under the scope of the right to freedom of thought, to alter thoughts or to reveal unexpressed thoughts. So at least in theory, with neurotechnology, we now have a technology that may actually do these kind of things. And just to give you a little bit an example, so when it comes to brain reading, so reading brain signals to infer mental states, this is really going at a very high speed. So whenever I update the slides and I look into the latest research, there's another paper which has another breakthrough. It's really coming all 3 months. There's another breakthrough at the moment. So what you see on the bottom here, so this is already 10 years old, and you see images that people were seeing, and then you see what they reconstructed, the lower level from the brain signals. That is not particularly good, but it's getting there, and this is already 10 years ago. And now in the latest kind of things that are published last year, they work by decoding. So when you close your eyes and you go into an inner dialogue, you talk to yourself, but you need to talk to yourself. So you don't need to verbalize it and to speak it out, but you have this inner monologue or dialogue when you speak to yourself in a clear way. And this is something that they can now, under very controlled laboratory conditions, they can reconstruct quite well. So the inner dialogue, if it's in speech, can be reconstructed. Now, this is still far away from, a police officer using this, but it's quite clear where the direction is going, and I think it's quite clear where the human rights concerns with such a technology lie. And I said, so because there's a lot of data processing, this is really where AI and neurotech come together and make quite a lot of advances in a really rapid pace. Okay, so this is neurotech background. Now let's go to the right again. What does the right to freedom of thought now really comprise? What's the scope of the right? What does thought mean here? Nobody has an answer. There's no authoritative material. No one has defined it. So I don't want to go into this debate now, but I would just make the proposal. Let's understand thoughts, ordinary meaning, thoughts as particular mental states with content, whatever that means precisely, and thinking, specific mental activities that we usually call thinking, like reasoning or remembering or calculating, those kind of things. Let's work with this kind of definition. Some will say it must be broader, some will say it should be narrower, but I think this is probably a good start. And then the other part of the right is, of course, the question what interferes with the right. I have already said, well, even the delegates said, well, rhetoric and persuasion, that cannot interfere with freedom of thought. Everybody agreed on that. But more substantive kind of interventions probably do. And so we have a lot of examples that somehow share the feature that they work with control bypassing means. So if I put electricity to your brain from the outside and to change something in your brain, many people would say, well, that is undermining my control over my thoughts, even if I don't have full control anyway. But this seems to be a kind of an intervention that's bypassing control, and that would qualify. And especially when those interventions are not communicative. So whenever we do communication, of course, there's all kinds of tricks and all kinds of different levels and all kinds of influences, but that is perhaps part of human interactions. It has to be somehow more than that. But for instance, subliminal stimuli, that was a thing in the 70s, stimuli you cannot see, you perceive them, but they're below the threshold of consciousness, they may qualify perhaps as well. But most would agree that at least those neurointerventions would probably qualify. So for the sake of argument, let's just assume these are the interferences, because this would then allow us to come to the third question: is this an absolute right? And that's the question I want to talk about. So what does it mean for something to be an absolute right? So how I mean it here in the same way as perhaps you're more familiar with speaking about unconditional rights. So a right that cannot be balanced against another right, right? So this is an absolute right. I'm not meaning absolute in the sense that the right holder cannot consent to interferences. So this would be a different understanding of absolute. I don't want to speak about that one. So traditionally, freedom of thought is seen as an absolute right. But now this is being called into question by my colleague George Leithart from the Netherlands, but perhaps more importantly, also by international institutions who are working on, for instance, the Human Rights Council Advisory Committee, which is the institutional successor to the Commission on Human Rights, which developed the Universal Declaration. They are at the moment drafting international guidelines on human rights and neurotechnologies, and they would probably have to take a position on this question. And in public and non-public debates, this is really one of the things they are discussing about. Should this really be an absolute right? Or is this not more an idea that they had in the 40s that perhaps don't fit into our age? So these are the debates, and the debates basically have two arguments. The one is that the historical records are disputed. So the argument is perhaps they didn't mean it to be absolute historically. And the other more interesting argument is that they come with a lot of counterexamples where they say, look, if this is an absolute right, then there are certain practices which seem to contravene this. Therefore, either we should give up these practices or the right is not absolute. So given that I think I'm already short on time, let me just get the historical part out of the way. I did some research on Charles Malik, who was the first to introduce the idea of freedom of thought in the Declaration. And what you see here is his handwritten note, which I found in his personal documents in the Library of Congress in Washington, where he was writing this on the bottom. This was his proposal accepted by the working group. And so this was perhaps one of the first notes where freedom of thought is mentioned. And already there, he claims, or he describes it as an absolute and sacred right. And the sacred comes from freedom of religion, or here it says freedom of thought and conscience. So from the very beginning, from the first emergence in the debate at the Universal Declaration on this right, it was conceived as an absolute right. And this, you can also track this in the documents, of course. And then after 1.5 years later, when they adopted the Universal Declaration in Paris, this is just a quote from one of the delegates, practically all the representatives had expressed their fear of seeing the different forms of freedom of thought restricted in any way. So from the beginning to the end, we see this commitment to the absolute character. And then the Universal Declaration was adopted, and then the work on the ICCPR continued. It already happened before in parallel. And this is a summary by the then Secretary General, just reading the yellow part. He's summarizing the debates, and he says, no restrictions of a legal character, it was generally agreed, could be imposed upon man's inner thought or moral consciousness. So to me, these are all very clear, and I can give you, of course, many more historical examples that historically this was meant as an absolute right that cannot be restricted. However, the report then goes on and basically says, but the delegates didn't really know what thought means in comparison to opinion and belief, so it wasn't really clear. So the idea is, we say there's an absolute protected part of the human mind, and we are very sure about this, but then we don't really know what it means. So we must say this is kind of like the historical situation. Okay, so much for the historical part. I will get back to this. Let's come to the interesting argument. So this is the argument now. If freedom of thought is absolute, then please explain certain practices. For instance, coercive psychiatry. So in psychiatry, we sometimes inject people with psychoactive drugs to change how they think against their will. This is a well-established practice, for better or for worse. This is something we do. Then the Pink Floyd argument. What about educating children? So this is definitely quite a lot of influence on thinking, shaping how they think, shaping how they see the world, perhaps for the rest of their life. Or what about self-defense cases? You can make up these cases yourself. What if the attacker comes and all you have is a mind intervention to stop him? Should you really not be allowed to do this? An absolute right would perhaps say no. Or what about a witness, let's say in a criminal case, who has to appear in court and has to testify? Well, this seems to require that that person remembers what happens. So he has to perform particular mental actions, remembering, because only then he can testify. So the duty to testify seems to entail a duty to perform certain mental acts. So these are counterexamples against an absolute nature. And I think prima facie, they have a point, of course. But, and now this is where, of course, I want to argue against this. I think one can construct the right that we can diffuse these counterexamples, but still keep an absolute right. But before I do this, I will, of course, grant the critics that the reason that this right has no practical relevance so far hangs together with this absolute nature, because no judge, no court wants to touch something like this and set a precedent. Very understandable. Nobody wants to touch it. So definitely there is a connection. And so if you want to have a practical and effective right, this is how the European Court of Human Rights always says, if you want to have practically effective rights, then perhaps revising the absolute nature might be a good move. Okay, so this is what I want to say up front. Now, also to make clearer, what do I mean with defending absolute right? So we have to separate different levels of argument. So we can talk about ethics. And in ethics, many people are consequentialists, and that's a very understandable position to have. And if you're a consequentialist, you're basically saying an action is good if the consequences are better than the alternative. So whenever you come into a conflict situation, you look for the consequences and only for the consequences, and then absolute rights are very hard to defend. Why? Because you can always come up with the case that the consequences for observing the rights are much worse than for breaking the right. And these are the ticking bomb scenarios. So should we torture the terrorists? We say, no, we don't want to torture. But what if we save 5 people, if we save 10 people? What if we save other people from being tortured? So you can always raise the stakes, and then in a consequentialist perspective, there will be no absolute rights. I think that's fine, but I don't want to talk about ethics. I want to talk about law. And I would agree that perhaps sometimes ethics, an ethical decision may be one that breaks the law. So I can live with this. Other people may not feel that this is right, but I think if we confine our arguments to the law, then the situation is a little bit different. Now, let's talk about absolute rights in the law. Now, a standard position would say, okay, we accept that there are human rights, but there shouldn't be absolute rights. So we just have a list of rights, let's say 20 rights, but none of them should take priority over others. None of them is absolute. I would think this is how the Canadian Constitution works, if my friend told me correct. There's a general limitation clause, so there is no right is absolute, but there are fundamental rights. I think, of course, there's nothing wrong with having such a legal system, but I think nonetheless one can ask several questions. One can still ask, even in such a system, is really anything allowed? So is it really the case that nothing is absolute. And then one can come up with examples in the literature, for instance. Is it really possible that the state could legitimately rape someone? Or can the state really legitimately punish an innocent person? So for different reasons, these things seem to say, or perhaps not. So perhaps even in such a system, there are absolute domains. And then perhaps there's a difference in legal tradition. So perhaps certain legal systems don't state a priori in an abstract way, this is absolute, this should never happen, but they will just go through the ordinary testing of the case, and then effectively certain things will never be allowed. So perhaps they, even though there is not a saying, the state shall never rape someone in an abstract sense, it could be that however we make the cases, in practice, it will never be allowed. So I think then we just see differences between, bottom up and top down legal systems, common law, civil law kind of systems, and that's of course fine as well. So I don't want to argue against this. Having said this now, I think I nevertheless want to give some arguments why you want to have absolute rights at all, even if you are from a system that doesn't have these. And I think one of the more interesting arguments has to do with you want to protect certain axioms of the legal systems. So here's an example. Many legal systems, I'm sure the Canadian one as well, they presuppose the autonomous person. That is kind of like the figure that is always in the background of all the kind of rules in civil law and criminal law and so on. And because a person is autonomous, the state respects the decision of the person on the one hand, but also ascribes responsibility and liability. That's basically the setup. If you operate under such an idea, if that is the axiom, then the legal system may want to protect the preconditions of the autonomous person, because otherwise, at least, the practice will get inconsistent. So if you say you manipulate the person very strongly, then either you give up that this is an autonomous person, or you can also say, then we don't make a responsibility, but it's about protecting kind of like these axioms. In the German constitutional tradition, we have this idea of the person as a subject. So the idea is not only as a legal subject, but also as a subject. We treat persons as subjects, not as objects. That's a little bit of phrase, and it needs specification, but that's something you come to at very different places in the law to come back to this. Okay, there's a basic assumption that the person should be treated as a subject, and therefore certain other rules follow. And now in international law, perhaps if we look at the Universal Declaration of Human Rights, Article 1 says all human beings are endowed with reason and conscience. That's an axiom. We assume so, but perhaps this quality can be undermined. So then Article 18, which protects conscience and thought, might be protecting the axioms of that system. So those are kinds of ways how you can think about absolute rights or why you should have them. Now, in the specific case of freedom of thought, let me give you some of the reasons we find for the absolute nature of that specific right. So one of the idea of personalism, that was a philosophy very big in those days when the Universal Declaration was drafted. And so very roughly, the idea is that they say, look, human rights encapsulate the idea that somehow the person comes before the collective. The person comes before the state. And that means that we cannot sacrifice the one for the many. That's the idea of human rights. So they assume this is the case. Now, but if this is the case, one can ask, what precisely is it about the person that cannot be sacrificed? What's the core of the person? And then Malik, for instance, says, well, the mind and the conscience, that are the most valuable properties. So he says possessions of the person. So if we want to say there's something about the person that has some priority over the state, then it could probably be the human mind. Now, you can have an existentialist reading, my reading of Malik, he would not agree probably, but you can say, but this is what comes from his writings, the question with human rights is always, why should we have human rights at all? You know, how can we justify them? And why should they be universal? And there's an existentialist way of addressing this. And this says, let's basically look at the situation all humans face. And we're all the same in this respect. And so the existentialist says basically, look, we're living in this world and we're thrown into this world. This is a typical formulation of the existentialist. Thrown into this world, we are there and we don't know what to do and what's going on. So the first task, the first challenge of every human being is trying to make sense of the world and trying to make sense of oneself and one's role in this. And this is a universal kind of feature of the universal human condition. And to master this, Malik says, therefore we need at least reasoning to understand the world, to think about the world, self-reflection, these kind of things. And those things are something that states can never take away. Of course, that is smuggling in a normative argument, but I think this has some, at least prima facie, perhaps, plausibility. And the last argument is that it goes much back to Hobbes, and we find it in Kant, is that what is the legitimacy? Why is state use of power legitimate at all? And then the reasoning is often, yeah, so because there's conflicts, humans have conflicts, and so we need to kind of like appease this conflict, and these conflicts are always in the external world. So in the external world, the actions of one collide with the actions of the other, is how Kant would have said it. And that is why the state can interfere and make rules and kind of like appease this conflict. But it's very clear that the state is only legitimately acting if he really appeases these conflicts. And because these conflicts are all in the external world, the legitimacy of state power is limited to the external world. Everything that's internal to the person cannot directly conflict with anyone else. So the state would be ultra virus, so to speak, if you would regulate the internal. That is an old line, and it's in the background of freedom of thought. Okay, so these were just some arguments. I know these were sketches. All of these arguments, you would need a full lecture to really flesh them out. Luckily, I just don't want to argue on this level. I just wanted to make it plausible that you could have an absolute right. I now go back to the level to the positivist level and say, okay, philosophical backgrounds to the side, can we diffuse these challenges that I gave you? And I hope I still have a lot of time. Yeah, so I should. So, of course, arguing with counterexamples is always a little bit weak in the sense you can simply bite the bullet, as a philosopher would say. I don't know if legal people say this in English, but you can always say, okay, then we just change our practices. Then we just stop with coercive psychiatry, for instance, which is, as those of you who are familiar with it, is highly controversial under the Convention of Rights of People with Disabilities anyway. So it's a very controversial practice. So one can simply evade this by saying, we're not going to do this. However, I would grant that all of these examples show something that we would probably not want to give up. And so I want to make a three-step argument. I would say that the freedom of thought as a right is a so-called incompletely theorized agreement. And I will say the first step, and the second step is that I would say, in the incompletely parts, general principles of law should apply. And then this will allow us to single out some of the counterexamples. And the third argument is that there are certain inner tensions within the concept of freedom of thought, which will allow teleological restriction of the scope. Okay, this is the argument. So step one, incompletely theorized agreements. I don't know if this is a thing in Canadian law. It's not in German law, but I think it's in US law. So that is an idea by Cass Sunstein. And the idea is that often in agreements, we just agree on a mid-level kind of. So for instance, we agree freedom of expression should be protected, and we put this into a treaty, but the people do not agree on the reasons. So they do not agree all the way down. And they also often do not agree what this really entails. But we need to make agreements on this level because we will not find agreement if we would really work this out on these other levels. So many agreements are incompletely theorized, he says. And actually, human rights is perhaps the best example because all the delegates say all the time, okay, let's agree on this, but let's not talk about why we agree, because then we will disagree. This is something you can even find almost verbatim in the record. So it's a very good example for this. And I think, and this is why I gave you this quote by the Secretary General, in this case, it's very clear, everybody agreed on this is an absolute right, but nobody was really sure what thought means and how we can extend the concepts. So what follows now from incompletely theorized agreements? So Sunstein has its own theory, and I think he would actually go against what I'm saying. So this is my interpretation of him. I think if we have such a case, methodologically, we should preserve the parts that people agreed on and have more leeway in the parts that people did not really agree on. So I would say we should therefore apply to this case, preserve the absolute nature, but have some leeway in finding reasonable constructions on the other aspects. I think this is methodologically preferable to the move that the critics are doing now, by just saying, oh, look, we have counterexamples, therefore we throw away the absolute nature. Because I would say, no, this is where we have an agreement. Let's rather work on the other parts. Okay, this is the first step. I'm happy to hear criticisms. Now, what do we do in these incomplete parts? So this is the second argument. I would say this is an old idea, and you probably have it in Canadian contract law at some point. So all these negotiations never happen in a vacuum. Even the meaning of our words is only understandable, intelligible against the background of other meanings. And in legal kind of negotiations, we never argue all the way down. We have background assumptions that all of the parties tend to share and that are not made explicit. And in this case, these are general principles of law. So we also find this in the debates. You see, they all have a background assumption what law is and what is the function of the state. They may differ, they may not agree on all of them, but there's often agreement on general principles of law. So what I'm saying is, in those areas which are incompletely theorized, general principles of law should apply unless we have any indications that the parties did not want this. Then they can, of course, be overwritten. But in our case, there's no indication with freedom of thought that anyone was thinking about education of children or self-defense cases or these kind of things. There's no trace in the record. So it's very likely that they just assume these general principles of law will not be affected by this right. Now, I do understand that by smuggling in general principles of law, that's a little bit dangerous because now we have all the debates who decides what a general principle is, biases, hierarchies, westernized perspectives. I agree with this. But nonetheless, I think there are quite clear cases so that self-defense is a general principle of law. It's hard to deny. That's for many the first human right, even in a state of nature. You do not have to get killed by others, at least if you're innocent. It's a paradigmatic principle, I would say. And the other, that parents may have a right and a duty to educate their children, and this implies perhaps interfering with freedom of thought, is also something no one would have doubted. And here I think the difference between this case and the torture debate comes up, because, in the torture debate, we have a prohibition of torture. And I would say, if you make a prohibition of torture, then you cannot say, but it does, in self-defense cases, it doesn't apply, because these are paradigmatic cases why you have a prohibition of torture. So there, I would think the general principle that might say self-defense, and self-defense can include, under certain circumstances, also torturing someone, that is overridden because we have an explicit agreement that we do not want torture. And I think here lies the difference to our present case. Okay, the third, now the example that requires a little bit more explanation is the testimony case. So we saw the argument is, if you have to give testimony, you have to remember this is a mental duty, that's a thought duty. I agree, but freedom of thought means, or was always supposed to pertain to the inner side as an inner side. And it was always clear that the state has the power to regulate behavior. You may remember, I just gave you one of the examples for the absolute nature of of freedom of thought. That was really the argument. The state can control behavior, but not internal states. But that the state can control behavior was always assumed. So if the state controls behavior, that might imply mental duties. So if the police officer comes to you and say, please drive away your car, then this entails that you have to do some thinking exercises. Who am I? Where is my keys? Where can I park it? All these kind of things. But to say that this is really interfering with the internal part seems to me a wrong distinction between the internal and external. I would think the mental activities that belong to behavior and to performing certain conduct, that is not internal side. So we have to say, of course, the state can impose those kind of action-related mental duties. And this, I think, then also applies to testimony. So, of course, you have to remember, but it's basically a behavioral duty. You have to show up in court, you have to say something. This is basically the duty, and the remembering is the mental part that belongs to this action description, I would say. Therefore, I would think we can also exclude this from the scope, with the effect that then we will not have an interference with an absolute right. We will just have an interference with an ordinary right. We can do proportionality testing as we usually do. Okay, now I'm coming to the end. Oh no, I should add this little example. So you can ask further now, okay, granted, my story, but why then should the state not use neurotechnologies to enforce this duty? So let's say there is a witness and he has a duty to testify. We say that's okay, that's not a violation of freedom of thought, but then he doesn't do it. So why should the state then not take neurotechnologies and kind of like enforce this duty, for instance, by triggering the memory segment and making them speak? Or early in the 50s and 60s, they were doing research on these truth drugs that people don't want to talk and then they talk freely. Why should we then not do this? Or would you say this is allowed? And if you say this is allowed, then your right to freedom of thought seems to become a little bit a boring right. So I think here another principle comes in, and this is now a separate one, and you can agree with this or deny this without that this affects the freedom of thought part. But I think that enforcing duties by taking over the inner control of a person against their will, that is something that undermines, in the German way of thinking, the person as a subject, or perhaps in another way, the agency that we associate with dignity. So we cannot remotely control another person. And here's an example. This is from the 60s already. This is one of the most famous neuroethics examples. This was a Spanish neuroscientist, but I think he worked in Yale, Jose Delgado, and he implanted a neurointervention device in a bull, in the motor cortex of a bull. And then they let the bull charge, they motivated it. And then the bull was running towards Delgado, and he could simply turn off the bull by stimulating the brain, and then the bull stopped. This was in the 60s already. So this is quite a remote control, the motor cortex of the bull. And I say, well, if we would be doing this with humans, it would not be okay, but this would not be okay because we are undermining the agency of the person, the person as a subject. Okay, so this would be this is the argument why we cannot do this with someone, with a witness who doesn't want to give testimony. But this is, of course, arguable. Now, my last point against the counterexamples. This has to do with freedom of thought, as we have seen, it's a multifaceted notion. And on the one hand, it means thinking for oneself, so freedom from external interferences. But on the other hand, it also has a positive side in the means, not in the meaning of a positive right, but in the means of a positive capacity. It means to think in a specific way, to be able to think, for instance, rationally. And this it's not only rational, but to have higher cognitive capacities that allow a certain way of free thinking. So, for instance, Malik, as a philosophy teacher, would have always said, I want to make my students into free thinkers, but this requires a lot of education. This is nothing taken for granted. Only because someone isn't influenced by the outside does not necessarily make him a free thinker in the stronger sense. So, and if we look into the historical ideas, of course, when Kant and Voltaire and all of them speak about free thinking, they also mean this, that, you have to overcome your immaturity, you have to be courageous to do these kind of things. So freedom of thought is not only non-interference, it has also this positive dimension. And these kind of dimensions can come into conflict. So, and we have free thinkers today, perhaps, the flat earthers, these kind of people nowadays, those kind of people invoke freedom of thought. In a sense, they're right when they say, leave me alone, do your own research, freedom of thought. And freedom of thought is appealed to by the anti-psychiatry movement, which I have some sympathy, but I think in this case, perhaps they are overplaying their cards. So they say freedom of thought, no coercive psychiatry. And I would say, yes, but if the intervention restores or enables these free thinking capacities like rational thought, if it overcomes delusional thought, which is one of the things you often do in these coercive situations because people have psychotic episodes or so, then I would think, on the one hand, you interfere with freedom of thought as non-interference. On the other side, you augment the capacities, perhaps the necessary conditions for free thought. And in that case, when we have this inner conflict within the concept, then I would say this cannot fall under the absolute protection. Therefore, I would think the scope of the right should be restricted. In German, we say teleological restriction. I don't know if this is a word you use internationally as well. But the meaning and the purpose of the right of freedom of thought was not to outlaw or prohibit or ban those kind of interventions that make people into free thinkers. And this argument applies to the coercive psychiatry situation, but also, of course, to the education of children. Okay, so I think, yeah, my time is more than up. So luckily, I'm on my last slide. So what are the consequences of all of this? I think freedom of thought can be consistently interpreted as an absolute right in the sense that it's not open for balancing against rights of others, but under the exceptions that I have just outlined, it's incompletely theorized. General principles of law were not meant to be overwritten. Behavioral duties may need to be addressed separately, and there's inattentions in the concept, which would then speak for a teleological reduction. And this means, in effect, that, for instance, self-defense will be possible. Other limits may apply, like the one in the Delgado Bull case. And yeah, so I think with this kind of outlook, we would do what the drafters of the Universal Declaration, I think, would have wanted. They said it's an absolute right, but we would need to define what this really means later on, and then they never did it. So I think we can do it in this way. We don't have to give up the absolute status. And the challenge for the future, and all of you are invited to work on this, of course, we have to define the attributes of the right now more precisely, especially the thresholds of what is an interference, and then we have to apply it to different contexts. Yeah, and that's it. Thank you very much.
Thank you so much for this wonderful talk, and thank you to all of you for being here. It's an honor to say a few words by way of, I don't even know if I can call it comment on the thoughts of one of the pioneers in the field. So I'm not speaking to the question from the point of view of someone who is as intellectually equipped in the subject as Dr. Boblitz is, of course. And so if I were to use a metaphor, you just have a good portion of the steak, and now you're going to get very boring steamed broccoli as a side dish. So what I'm going to do here, just to say a few things about if actually this absoluteness that Dr. Boblets is advocating for is taking us where he wants us to be. And to do so, I should say that I actually agree with, I would say, more than 90% of what he has to offer. So here is where our agreement is, and here is what I ask a few questions. And imagine these questions to be just you're reading an essay, and you're making some comments on the margins as just some raw thoughts. So I'm fully convinced by the interpretation Dr. Boblets is offering of Article 18 and of UDHR and also ICCPR. I'm equally convinced about this internal-external distinction he's making. Also about the fact the abstract nature of the right of freedom of thought is not a defect at all. And I also can sympathize with the two-layered arguments that he's making. One is that the freedom of thought is separate from the sister rights, freedom of religion, conscience, etc., etc. And so they are distinct, although the other rights are derivative from this right. And also the second layer of the argument that the freedom of right itself should be considered an absolute right based on basically methods of treaty interpretation that he has so masterfully drawn out in his multiple works of pieces of writing, and so and relied on history as well. So a few very preliminary points. Dr. Boblets is heavily relying on the history of the UDHR. One could think that the history actually reflects legitimate fears about collectivism, about materialism, threats at the time to personal liberty. One could also think that this history, like any other history of treaty making, is the work of people with projects at the time. So even though it's based on the rules of treaty interpretation and also as a guide for us, all of this is a guide, but it's not really a sacred guide and could be diverged from. But that's not what I'm trying to do here. I'm just basically laying that on the table, that this history, as convincing as it is, reflects a particular way of thinking about freedom of thought, given the events of the time. Okay, so very quickly on absolute, when we think about, and Dr. Boblets very clearly described what he means by absolute here. When we think about absoluteness of human rights, we should think of the other characteristics as well. So in general, human rights are inherent, they are fundamental, they are inalienable, and all of these have different meanings in the doctrinal understanding of human rights. They are universal, etc., etc. So this is, so they are all of that, they are interdependent. And now on top, some of them are also or should be considered to be absolute. So this is in the domain of human rights itself. And now human rights norms share some other characteristics with general international law norms that are seen as higher norms. And so absoluteness is actually one of those characteristics. So the inalienable, universal, interdependent, those are specific to human rights. Absoluteness is a characteristics that some human rights norms share with other general international law norms. So the way it has been, again, we know that Dr. Boblets has emphasized that his most important definition for absoluteness here is the fact that the lack of possibility of balancing basically between absolute rights, here freedom of thought, and other human rights. But there are other meanings. So the fact that human rights cannot be derogated from, even in the states of emergency. And in one way you could say human rights are limited but not suspended in the pursuit of a legitimate aim, such as the protection of national security, public order, or public morals or health. And insofar as those are considered necessary in a democratic society. So then one could think actually that there is a more restrictive definition of absoluteness. Here you could think of two different groups. One would be people who think, or scholars who think, that absoluteness means being non-derogable, and that should be the nature of the norm itself. And some scholars even go so far as to claim that any additional qualification of the norm is actually, as a jus cogens, for instance, meaning higher norms of international law, those would not really add up much value here. Non-derogability is sufficient. There is an opposite view to that defines that absolute rights are rights that cannot be limited. Basically, it's not possible to apply the proportionality test to them, regardless of the possibility of their derogation. Okay, so I only mentioned that to say there are different ways of thinking about absoluteness, but we know how now we have limited here to the absence of the adjudicatory use of adjudicatory tools of balancing care. So the use of absolute as a qualifier in the human rights documents has been left very abstract and underdefined. It's mostly prevalent in the practice of the European Court of Human Rights, and also in the practice of the general comments of the human rights community. But mostly even there, interestingly enough, these bodies have left the definition completely underexplored and use the term generally as an accepted given. And so they've mostly relied on, one could say, an intuitive understanding of the right itself. So the most recent example is the 2018 general comment of the Human Rights Committee on the right to life, where the right to life has been interpreted not to be absolute in a specific sense. I'm not going to get into that, but it's not absolute. But we don't, still even in that commentary, we really don't know what absolute itself means. We only are given the description, basically, or the concrete example of the or interpretation of absolute, the non-absoluteness in the context of the right to life. Okay, so now what this basically, the concept of absoluteness conjures up is this idea of jus cogens that I just mentioned in international law. So basically the idea that the normative position of specific rights is higher than others in the system. So again, that very well dovetails with questions of constitutionalism in international law. So there's a hierarchy of norms. Obviously, there's no time to get to any of that, but basically it's very similar to those conversations about de facto constitutionalization of international law through affording different levels of normativity to some norms against others. So there is a correlation, so to speak, between the concept of absolute human rights and jus cogens. So why am I putting this on the table here? Because the idea is that under the best circumstances, when human rights norms, or some human rights norms, or a human right norm is considered to be absolute, under the best circumstances, it would be similar, basically, in treatment to some of jus cogens norms. So here is a question, and it's not too fanciful. So let's just think about some of these jus cogens norms that move from one area of international law to other areas of international law. And so they are defined differently across different fields of international law. So let's just imagine that one were to define the absolute or find the concrete examples deriving or resulting from the absoluteness of the freedom of thought in international humanitarian law, meaning the law of war, as opposed to human rights itself. And so in the context of other jus cogens norms, we see that there is basically fragmentation of interpretation among different rights when they are applied across different fields. And there is no reason to think that freedom of thought would be any different. So in the interest of time, I had here something to say about different philosophical foundations of freedom of thought and different meanings that one could, and the literature actually has offered, not necessarily in law or international law, but coming from neuroethics, and also coming, strangely enough, from political theory as well. And so that is closely connected to what Dr. Boblets closed his talk about, some of the positive obligations that one could expect to flow from an absolute norm of freedom of thought. But I'm going to let that be for now because of the time constraints that we have, and move to questions of adjudication. So here is what I have in mind when I speak about the fact that under the best circumstances, an absolute right of freedom of thought could be in good company of many international jus cogens norms in international law across different fields of international law. And so what happens in the context of actual adjudication? So obviously in the context of freedom of thought, we don't have concrete cases now, so we haven't really encountered those difficult moments when these higher norms, absolute or jus cogens or whatever you want to call them, because jus cogens norms, obviously, for in case a recap of international law is called for, jus cogens norms also are norms that are higher than other norms. They are non-derogable as well, and so they at least in non-derogability are not very different from many of basic foundational norms of human rights, and they are not subject to balancing, at least on the surface either. But here is what happens in actual, or what has happened in actual education cases. So I'm actually referring here to a very unusual case for this context, but I still think it's illustrative. And that's a separate opinion written by Judge John Dugard of South African scholar of international law. He was an ad hoc judge in the International Court of Justice. The year is 2006, and the case is Democratic Republic of Congo versus Rwanda. again, I'm going to skip the details of the case very, very generally only and briefly. There is a question of basically conflict, the supposed conflict between a jus cogens norm and between and a general principle, or what was taken to be a more a general principle of international law. Actually, it wasn't described as such either. It was described as one of the fundamental pillars of international law, which in this case was state consent. So here is what Judge Dugard says. I'm just probably picking up some of my in-class habits to give paragraph numbers for further reference, though it's not necessary here. So in paragraph 9 of the separate opinion, he talks about the wealth of material on judicial decision-making in national law, but the fact that in international law, we have not really theorized judicial decision-making as much. Then he moves on to say that the judicial decision is essentially an exercise in choice, very much a policy-oriented, at least there is the air of policy-oriented approach here. So it's essentially an exercise in choice where authorities are divided or different general principles compete for priority, or different rules of interpretation lead to different conclusions, or state practices conflict. The judge is required to make a choice. So in exercising this choice, he continues, basically, the judge will be now has to basically balance of policies to arrive at a coherent conclusion that most effectively furthers norms of jus cogens of international law. So jus cogens norms, he continues, are actually, it seems that they are, they basically affirm they're a blend of principles and policies. They policies are goals here, principles, we know what they are. And in different cases, basically they embody different, the judge would have to look at these different principles and policies at the same time in this act of balancing. Okay, so now then he goes on to make a comparison between some other cases, not relevant for us here, where basically the choice was between a jus cogens norm and something that was not, of a higher value, or something that was a jus cogens norm, but probably a bit more controversial. And then he says there that, look, that is much, much easier because basically the judge then is working at a molecular level, so to speak, not at a molar level. So speaking, using some chemistry concepts, so it's not, but when the judge is confronted with a case where the choice is between a jus cogens norm and a fundamental norm of the system, and here is consent, then jus cogens norm may not basically give us the kind of normativity that we expect. And so this separate opinion is illustrative to me to suggest that the kind of absoluteness, and I know that I'm not here giving any concrete examples, so it may remain very abstract, but remember the whole normativity of this right is very abstract in and of itself as well. This separate opinion, which is basically stating what anyone familiar with international legal adjudication already knows, but it just articulates it in such a clear way, is that the absoluteness, this characteristic of absoluteness, which seems to be the desideratum here, may really not give us what we are hoping. So what to do? Should we question that? Perhaps not, because as I mentioned, I agree with the interpretation, the doctrinal interpretation that Dr. Boblets is offering, supported by positive law. But I'm also conscious of the fact that the auxiliary factors, such as the historical background, all of those could be taken again as different parts of the UDHR being basically the product of the thinking of and projects of specific people at a specific time. And even though we are bound to keep the spirit, and also we are bound by the rules of treaty interpretation for literal meaning to the extent possible, but maybe overemphasis that on that originalist reading of the first paragraph of Article 18 of the UDHR and then ICCPR, that may lead us to the formalist conclusion that is desired, but may not necessarily lead to protecting the sacredness of the mind. And given that we don't really have any time left, I'm not going to speak to that, but I think there is something to be said about whether really the mind is the most sacred of what any human being possesses or not. I think that could be questioned depending on what perspective you're taking. But regardless of that, maybe the absoluteness, maybe this interpretive word takes us to absoluteness in a positive law or formalistic reading of the convention, but it may not necessarily guarantee the results that we expect to get from that formalistic reading. And I'll just end here and leave it to Dr. Boblets for, I'm sure, many questions that I have.
Thank you for a very fascinating discussion. I just wanted to open it to any questions from people here or online. Welcome.
Thank you. Thanks for this fascinating talk, and thank you, Professor Sutherland, for posing these questions as well. So my questions are sort of interrelated. I'll be honest, I don't know much about freedom of thought, but I was interested in looking at how the legislative measures have been approached to protect sort of cognitive freedom of thought, especially in the EU, given the requirements of the DSA as well as the UAI Act. So if, let's say, something like an Article 5 of the UAI Act, which perhaps puts forth the threshold saying, okay, banning certain types of technologies which cause extreme harm or significant harm and so on and so forth. So my first question is the threshold, does that even make sense from a freedom of thought perspective? Given even in Canada, for instance, we have the erstwhile AIDA, which also had the harm sort of thresholds, right? And is necessarily the freedom of thought an individual right in some sense, or have the legislatures essentially taken it as an individual right, while allowing societal and economic consequences to follow through? So in the example that I want to take is the banning of workplace technologies which harm individuals or employees at workplace, right? Or biometrics, but allowing for chatbots and generative AI to come in because they don't cause significant harm, but nonetheless might affect freedom of thought individually as well as more broadly society as well. Thank you.
Yeah, thank you very much. So in general, I would say that the lawmakers, of course, have a positive obligation. Our state has a positive obligation to kind of like implement measures that protect freedom of thought. And I would say they have not done so systematically, even though freedom of thought, it's often put into preambles or into recitals in European context, but they haven't really systematically done this, and the EU AI Act is a good example. So we have a full prohibition of emotion recognition systems in certain environments, but not on thought reading devices, which is obviously inconsistent from the freedom of thought perspective. So I would, and on that level, of course, lawmakers have a lot of discretion, so they can, and they should try different ways, and my work at the moment is to get them to do anything. So for instance, with digital technologies, there is something that has come up also in one of these reports that I showed earlier. Why don't we do something like a freedom of thought impact assessment for digital technology? So, and then we probably have the question to come back to the other, what are the thresholds? And in those legislative measures, I would think we can't deduce the threshold from these abstract human rights considerations. This has to be more grounded, it has to be substantial, but lawmakers are not prohibited from, making stronger levels of protection in ordinary domestic law than what they would be obliged under international law. So I think this is really something we can look. So the threshold question is something we can look at when we talk about national legislation separately from this, but of course, in freedom of thought and the abstract debate, there's also a question about the threshold. How strong does an influence have to be to violate freedom of thought? And I think there the answer is it has to be substantive. If we talk about an absolute right, it must be really severe kind of influences. So most of these digital service act, I think, will probably not qualify.
Thank you. I think we have time for one more question, please. Yes.
Thanks, thank you. Listen, just a quick question. I wasn't sure what your position was on, let's just say, course of psychiatry, specifically, chemical restraint on an individual. But then, say, let's not even talk about the state, let's just say on the cosmic level, we're going to sort of, you're restraining an individual chemically, there's no physical restraint, but where's that threshold? So,
I mean, that's definitely the thorny question, also ethically and medical ethics and so forth. I would just say that if these medical interventions are giving to a person in a state who's not competent, this would be a background assumption I would be making. In order to restore non-delusional thought, I would think it does not fall under the absolute protection, but this does not mean that therefore everything is allowed. So then we still would have other rights that this would fall under. Mental integrity, for instance, is one that we could use in the European context. You could also use physical integrity, which you probably have in the Canadian Constitution, or you have mental integrity in the American Convention at least. So you would still have these kind of the typical proportionality test. I would just say it's not, if it's enhancing freedom of thought or it's restoring freedom of thought to a minimal level, then it doesn't fall under this absolute prohibition. Which leaves me, and then of course we have to differentiate what are the conditions we are treating. So I'm thinking about delusional thoughts, clearly instances of psychosis, these kind of things, where I would clearly say there's a deficiency in free thinking here because of obsessive and non-rational thinking. Of course, there's a normative standard here, but I would think one can defend it. But there are many other things that people might be treated for involuntarily, which would not fall under this category, affective disorders and so on. And then I think we would have to look at the case, and my argument might not apply.
Thank you. Thank you everyone for attending today, especially our distinguished speakers and the York Center for Public Policy and Law for supporting and making this event possible. I'd like to thank all of our engaged audience, both in person and online. We are so grateful you joined us today for a very important discussion. Thank you.